You're very, very welcome along to the third in the series of the Irish Red Cross and Ukraine Ireland Legal Alliance Legal Information Webinar Series. This evening, we are speaking on the topic of housing rights. The slides will be in Ukrainian. The presentation will be in English. Our presentations this evening are with thanks to McCann Fitzgerald and A&L Goodbody. Our presenters tonight will be, first of all, Ethna Lynch of A&L Goodbody, and second, Edel Finn of McCann Fitzgerald. This evening's session is regarding housing rights under Irish law. It will not deal with individual requests for accommodation. At this point, I'm going to hand over to Ethna Lynch from A&L Goodbody to take the first part of the presentation. Many thanks, Ethna.
Thanks, Rose. Good evening, everybody. Delighted to be here today and to hopefully share some insights around the provision of accommodation for beneficiaries of the Temporary Protection Directive. Myself, I'm a practicing solicitor. I head of the pro bono practice at my firm. I am going to read some information from a document just to make sure that I'm staying very clear. If I'm speaking too quickly, I would just ask that you please say it in the chat and I'll do my very best to slow down. I will speak for about 10-15 minutes and then I will hand over to my colleague Edel Finn. The portion of the presentation that I am going to cover is around state-provided emergency accommodation, the recent changes in the rules, and I'll also talk about the recent changes in social welfare. So the slide that you see there on the screen, this is, I suppose, to explain that emergency accommodation for beneficiaries of temporary protection, it can come in many forms. So with the Temporary Protection Directive, it was enacted really to support a large population to flee from the war, but then also to be met with support here in Ireland. So you will see on that slide, state-provided emergency accommodation. It can be in the form of a designated accommodation centre. There are 6 currently taking in new arrivees that need accommodation. And the Department of Children, Integration and Equality, they update their website regularly. So I would encourage you to go to that department if you're looking for new information. There are also emergency rest centres, student accommodation sites. They will often be used during the summertime when the students are on their holidays. And then finally, there is the use of hotels. So if I go on to the next slide, please, Rose. So there has been concern and confusion around the announcement. Sorry, back to the previous slide, Rose. Concern and confusion around recent announcements around the provision and the duration that you can stay in emergency accommodation. And for people arriving new into Ireland from the 14th of March, they will only be provided with 90 days accommodation, and then they will be required to leave. Secondly, when somebody is in, sorry, Rose, if you could just go on to, oh yeah, sorry, you're on the road. I was looking at the wrong screen. So also, if somebody or anybody on the call here is in a designated centre, so an emergency accommodation centre, and meals are being provided, there is now a requirement that a small financial contribution is made to the cost of that. So if you go to the next slide, Rose. Actually, just before I go to that slide, I will just, for complete clarity, the government announced changes to the provision of state support to those availing of temporary protection in Ireland. As I said, from Thursday, the 14th of March, individuals fleeing the war in Ukraine who register for temporary protection and are seeking state-provided accommodation will be accommodated for a maximum 90 days. This change, as I said, will not affect people from Ukraine who arrived in Ireland before this policy came into force and are already registered for temporary protection. In the emergency accommodation centres, as you can see from the slide there, you will be provided with food, laundry and other services and integration supports set up at those centres. If you're staying in accommodation where food is provided, individuals are currently required to pay a contribution of €10 per day for adults, €5 per day for children. Noting, however, that you do not have to pay this in your first 2 weeks. However, after that point in time, if you refuse to make the contribution, you can be asked to leave. So if we just go on to the next slide, Rose. So in accommodation centres, there are a series of rules that you will be asked to, I suppose, adhere to. That is the absence policy, refusals policy, antisocial behaviour policy, and pet policy. All of these policies are available on the department's website, but for the provision of information today, I'm just going to give a little bit more information about each of those policies. Oftentimes, people will be concerned that if I leave short-term temporary accommodation and I am a beneficiary of temporary protection, what are those consequences? So from October last year, beneficiaries of temporary protection can only be permitted to be absent from state-funded accommodation in exceptional circumstances. So that is quite different to what it was previously, where you could be absent upwards of 7 calendar days over a 6-month period. That has now changed, so you must remain in the accommodation. You will be allowed an overnight absence in exceptional circumstances, for example, to look for your own accommodation or to facilitate search for employment. If I move to that second bullet point, this deals with refusal policy. So the refusal policy applies to all short-term temporary accommodation, including serviced accommodation, designated accommodation centres, offer of pledges, vacant home, and rapid build housing. If you refuse an offer of suitable accommodation, then no further offers will be provided from the department. And the department will also be reluctant to provide an alternative form of accommodation for reasons of employment, school, family reunification, or other non-medical reasons. And I say this clearly because before we had this session this evening, that was one of the questions I know that we had received in from potential attendees this evening. All accommodation centres will also have a policy around what is called antisocial behaviour. So really this is to ensure that there is good conduct towards other beneficiaries at the centre, but also the staff. And if there's a minor complaint, oftentimes it will be a verbal warning. And then there will be rules within each of the accommodation centres to I suppose, mediate and try and resolve an issue at the centre. If there's an allegation of antisocial behaviour against you and it is found to be true, then it is likely that you will be asked to leave and there would not be an alternative offer of accommodation made. Finally, if we look at pet policy, when the beneficiaries of temporary protection first arrived in Ireland, it was sometimes the case that pets were permitted to reside at emergency accommodation centres. That is no longer the case. So if you are availing of a state-funded accommodation, you will not be allowed to bring any pets into the centre. And the department have made it clear that it is your responsibility to make the arrangements for your pets at your own cost. Okay, so if I move on to the next slide, we're going to now look at social welfare benefits. So again, a couple of months ago, there was an announcement made in March around the provision of social welfare. Okay, for anybody on the call this evening, if you registered for temporary protection before the 14th of March of this year, you can apply for social welfare assistance in the same way as Irish citizens, as long as you meet eligibility criteria. So, for example, you can apply for a job seeker while you're looking for employment, or if you have a disability, that you can seek to apply for that as well. And if you're registered for temporary protection and temporary accommodation after the 14th of March, standard social welfare is no longer available to a person while they're resident in a designated accommodation centre. Instead, those individuals will get a reduced weekly allowance of €38.80 per adult and €29.80 per child. And a monthly child benefit will be paid for qualifying children. So the government did bring those changes in through legislation, and they are now in place. The other thing, on that, that was made on legislation. So if we go to the next slide, there is going to be further changes. Slide 7. Thanks, Rose. So another concern, I suppose, and it was an announcement made in May, that there will be changes to social welfare. I think you're on the wrong slide, Rose. It's slide 6. No, go back a few. Yeah. That one. It's that one. Yeah, thank you. So sorry, let me just get my bearings here. So we've covered that. So yeah, if we go on to slide 7, there was the next slide. It's upcoming changes to social welfare rights. This applies to beneficiaries in state provided accommodation. So on the 14th of May, the government issued a statement saying that they had agreed that all beneficiaries of temporary protection in state provided serviced, so where food is provided, accommodation, they should receive the same level of payment regardless of when they arrived. These changes haven't been made yet, and the government has announced that there will be a 12-week lead-in time. But essentially what that means is, if you arrived in Ireland before March of this year and you still reside within state serviced accommodation, it is likely that by August, if you are in receipt of any form of a social welfare benefit, it will be reduced to that payment of €38.80 for each adult and €29.80 for each child. We don't have a date of when that's going to happen, but we know that that is the policy change that is going to be coming down the line. If we go on to social housing supports, a question that we got asked in advance of doing this presentation was whether or not beneficiaries of temporary protection can apply for social housing, so a long-term social housing application. And the answer is no. So that is not available. That is available for other categories of individuals who have been determined that they will remain in the country long-term. However, there is a social welfare payment that is available to beneficiaries of temporary protection, and it's called rent supplement. So if we go on to the next slide, Rose, I can explain a little bit what that means. So this is a qualifying social welfare payment, okay? And you must meet certain criteria. So you're not going to qualify if you're in full-time employment or are married and or are living with a partner in full-time employment, are registered as a full-time student. And that final one generally, where you are in receipt of HAP, you cannot apply for rent supplement. However, in your circumstances, it doesn't apply because you're not eligible for it, okay? And then the other thing is that this is a means tested benefit, and it is managed by the Department of Social Protection. So bear in mind that if you are already in rented accommodation and it is becoming expensive, or you feel based on the criteria that you may be eligible for a rent supplement, please do go to the intro office in your locality. They are very, very good, and they will be able to provide you with more information, and because it is means tested. So the final slide that I'm going to cover today, and again, it was on the basis of questions that we were being asked in advance of this presentation. And it was, I suppose, for us to set out clearly certain rights that flow depending on whether or not you're an international protection applicant, you are someone who's been granted refugee status or subsidiary protection through the International Protection Act, or you are a beneficiary of temporary protection. Because one of the questions we had got asked was, well, if you're an international protection applicant, can you access the housing list? And the answer is no. So as you'll see on that slide, if I deal with right to work, international protection applicants have the right to apply for access to the labour market after 5 months. And that is a right to apply. They then must wait for that permission to come through. And because of bureaucratic delays, at the moment, processing times are taking longer than that. So currently they must wait until they get that permit to even start to seek employment. Once somebody who's been in the protection process and they are granted a positive decision, then they can access the labour market immediately upon receiving their status. Beneficiaries of temporary protection, there's immediate access to the labour market with your temporary protection letter. So the accommodation, if I move on to that point, that's provided by the International Protection Accommodation Service while the application is under consideration. There is court proceedings ongoing at the moment because there are several, well over 1,000 international protection applicants that are currently not getting any accommodation. So once they are granted protection, so if someone is deemed legally to be a refugee or entitled to subsidiary protection, which again is just another legal permission, they have no automatic entitlement to housing. At that point in time, they must make an application, and they also have to show that they meet those financial thresholds. And then finally, for beneficiaries of temporary protection, new beneficiaries have a 90-day entitlement to state-provided accommodation and, subject to qualifying criteria, have access to rent supplement to help pay the cost of private rent. Finally, the point that I would make around social welfare. So international protection applicants have no entitlement to social welfare in Ireland because they're in centres where their shelter and their nutritional needs are being met. They will get that reduced weekly payment of €38.80, as I've mentioned before, and €29.80 for each child, and they are not entitled to child benefit. Once they are granted protection and have the right to live here in Ireland, then they will have the same entitlements again around child benefit, around kind of any social welfare benefits and housing, subject to any qualifying criteria that apply to those benefits. And then finally for social welfare, on the final column, for those of you on the call, that's most relevant in state-sponsored accommodation from the time kind of going forward, it's going to be that reduced payment. And then if you are not in state-sponsored accommodation, you have the same entitlements to Irish citizens. So like that, being able to get job seekers benefit or a disability benefit, or where you are renting privately and need support, you can make an application for rent supplement. So that brings to a close my section. I'm going to hand over to Adele now, who's going to, I suppose, focus on other aspects of the provision of accommodation in Ireland. So thanks very much for your attention.
Thank you very much, Etna. I hope everyone can hear me okay. I won't introduce myself again, but my name is Adele Finn. I'm now going to discuss what rights a beneficiary may have while living with a host in pledged accommodation or in private rented accommodation. So as Etna has mentioned already, the Department of Children, Equality, Disability, Integration and Youth oversees the accommodation of displaced Ukrainians in pledged accommodation, as well as emergency accommodation. So Rose, if you, yeah, perfect. If the previous slide. Thank you. So what is pledged accommodation? Properties which include both vacant properties and private rooms or shared accommodation with their hosts are offered or pledged by private individuals to the organisation responsible in providing the accommodation to displaced Ukrainians. These different schemes can include the local authorities offer a home scheme, which relates to vacant and unoccupied properties, and then the Irish Red Cross Register of Pledges scheme, which relates to both vacant properties and shared accommodation in the host's homes. This scheme is also supported by other host programs run by Helping Irish Hosts, International Organisation for Migration, and the Peter McVerry Trust. And in addition, private individuals are also offering their homes directly to Ukrainian people, and this may be done independently on social media groups or other websites like that. So on to the next slide. I will first discuss briefly what your rights and entitlements are when living in these types of pledged accommodation. So what are the main differences between living with a registered host and an unregistered host? A registered host is someone who has formally pledged their accommodation through one of the official organisations. So that means that the properties are inspected in advance. Hosts and their families are Garda vetted if they are sharing their homes with Ukrainian families, especially those with children or vulnerable people. And a screening process is carried out before the hosts and the properties are approved. In the case of an unregistered host, these accommodations are usually offered through social media sites such as Facebook or Telegram. Unlike registered hosts, there is no screening or Garda vetting of the hosts, and there are no inspections carried out on the properties in advance. So if choosing to live with an unregistered host in this instance, common sense and a diligent approach should be taken. Whether you choose to live with a registered host or an unregistered host, it is important to be aware of your rights and entitlements when living in these accommodations. For both vacant accommodation and shared accommodation in a host's home, it is recommended that property owners and beneficiaries sign a temporary accommodation license agreement. So the department has a template license for vacant or self-contained properties, and Helping Irish Hosts have template home sharing agreements. Signing such an agreement protects the rights of the property owner, the beneficiaries, and the properties themselves. You should remember that in these circumstances, the agreements are licenses only, and that means that they can be revoked at any time which means that your host may ask you to leave at any time. It's important to know that this arrangement does not give any tenancy rights to the beneficiaries. It is recommended also that you agree at the outset who is responsible for paying utility bills or food and how much should be contributed by the beneficiaries. So on to the next slide, please. So if you live in pledged accommodation, the host is entitled to receive a payment from the government known as ARP. And ARP stands for Approved Recognition Payment, and it is managed by the Department of Social Protection. Under the ARP programme, there cannot be any rental agreement between the host and the beneficiary. Therefore, rent is not payable. However, additional payments can be made by the beneficiary in contribution towards costs such as utilities and food. Under the programme, the host receives from the government a payment of €800 per month. The host may be the property owner or a tenant in the accommodation, but they must have the consent of any other owners or tenants. This is a tax-free payment and it is per property, regardless of how many people are being hosted in the property. The accommodation must be provided for a minimum of 6 months, and Garda vetting is not a requirement to receive the ARP payment. On to the next slide, please, Rose. But it is important to be aware, in order for the host to receive ARP, the accommodation must meet required standards. This relates to all pledged accommodation, both shared and vacant properties, and it applies whether it is being offered by a registered host through one of the official organisations that I mentioned earlier, or with an unregistered host that you may have found through a social media group. Meeting these minimum standards is a legal requirement in order for the host to receive ARP. And the relevant legislation, just so you're aware, is the Civil Law Miscellaneous Provisions Act 2022, Part 2, Eligible Dwelling Standards Regulations 2022. The structural condition of the accommodation must be generally in good state of repair, safe and free from pests and vermin. And there are further detailed requirements set out in the government policy document, which is available on the government website online. Basic facilities should be provided, including a bathroom and a shower, heating, facilities to store, prepare and cook food, access to washing machines, an appropriate place to dry clothing, refuse facilities and appropriate fire safety equipment. And all of these facilities should be kept in a safe condition, in good working order and in good repair. So now on to the next slide, please. So now I'm going to discuss private rented accommodation, which will be useful in the event that your host accommodation comes to an end and you may need to rent privately. As Etna has already discussed the social housing supports that are available to beneficiaries, I'm now going to focus on the rights and obligations in private rented accommodation. So under private rented accommodation, your main rights and responsibilities or obligations as a tenant come from landlord and tenant law, as well as the tenancy or the lease agreement with your landlord. However, it is important to note that in this section, it only relates to the rental of an entire property or a self-contained unit. Rental of a room in your landlord's home is not covered by this landlord and tenant legislation. So the basic rights of a tenant include that the property must be in good condition and meet minimum standard requirements. You are entitled to peaceful occupation. You're entitled to a rent book, which records all rental payments. You have the right to contact your landlord at any reasonable time when necessary. In the event of a dispute, you may contact the Residential Tenancies Board, which is a RTB, and we can provide information on the final slide in relation to this. And you are entitled to receive a certain amount of notice if your tenancy is being terminated, and you should receive a prompt repayment of any deposit that has been paid. Next then is the basic obligations of a tenant, and these can include the payment of rent and any other charges on time. You must keep the property in good condition. There should be no antisocial behaviour in or around the property. You can request the landlord permission, or sorry, you must request the landlord permission before using the property for any other purpose. You must allow landlord access for inspections provided reasonable notice is given to you. You should inform the landlord of any issues or defects that may occur to the property, and you should comply with any other term that is featured in your tenancy agreement with your landlord. So I'm going to finally look at the last slide here, which relates to the termination of a tenancy. So if your landlord wishes to end a tenancy within the first 6 months, they are simply required to provide 28 days written notice. No specific ground or reason for the termination needs to be given to you. However, a Part 4 tenancy arises once a tenant has been renting a property for 6 months or more. And the rules relating to a Part 4 tenancy are grounded in the Residential Tenancies Act 2004. A Part 4 tenancy gives a tenant the statutory right to remain in the property for a limited duration, unless the landlord terminates with a valid and permitted reason. And these are set out in the legislation. And they can include failure to comply with an obligation in relation to the tenancy, such as the non-payment of rent or delayed payment of rent. The property is no longer suitable for the tenant's needs. For example, it has become too small for the tenant. If the landlord intends to sell the property within 9 months of the tenancy ending, the landlord requires the property back for themselves or for an immediate member of their family. The landlord intends to change the use of the property to some other use, such as office use. However, the landlord is obliged to offer the tenant a new tenancy if that change does not take place and the property is subsequently put out to be relet. And lastly, the landlord intends to substantially refurbish or renovate the property such that it needs to be vacated. And in this instance, the landlord is obliged to offer the tenant a new tenancy once that work has been completed. So that brings the end of those rights. The final slide are useful resources that we would want to signpost you to. So in relation to state accommodation, the Ukraine Crisis Temporary Accommodation Team, and the email address is set out here in the slide. The ARP payment is managed, as we said, by the Department of Social Welfare, and their email and their contact details are listed here. The local authorities have a community forum teams, and these are set up in every local authority, which should be available online. As I mentioned before, the Residential Tenancies Board looks after tenancy law in respect of the private rented accommodation, and their contact details are listed here. And finally, Threshold is an Irish charity providing free advice and support to people in housing difficulty or at risk of losing the rented home. So again, this relates to private rented accommodation. So that concludes our webinar this evening.